Welcome to the deep dive. Today we're taking a shortcut into a vital part of Turkey's legal system, its administrative jurisdiction.
Right.
Think of it as the rules governing how the government interacts with, its people and businesses. It's a system with some fascinating roots in France, actually, but it's got a uniquely Turkish evolution, really stretching back to the Ottoman Empire.
And that's given it its own distinct flavor, its own principles, its own ways of operating, quite separate from, say, criminal law or civil law.
It's a really compelling example, isn't it? How legal ideas can cross borders, but then they adapt, they transform based on a specific country's history and its needs.
Absolutely. You see those echoes of French influence, definitely. But Turkey has, well, it's written its own chapters.
For sure. And for our exploration today, we've got this great source, a legal text titled Ders İçdoğruç Yargılama Hukuku Ekitap.pdf.
Our backstage pass, you could say.
Exactly. So we'll be focusing on the key pieces of legislation that build this system. That's the Administrative Judicial Procedure Law Num 2577, the Council of State Law Number 2575, and Law Num 2076.
Right. The one that sets up the regional administrative courts, and tax courts, defines their roles.
These laws are like the absolute bedrock.
They really are. They lay out the who, what, when, and how of challenging administrative actions in Turkey. I mean, without them, you wouldn't have a clear framework for resolving these kinds of disputes.
Now, you're here because you want to get a solid handle on this area. It can seem complex, right?
Oh, definitely.
But you don't want to feel like you're swimming in legal jargon. You want the essential understanding, the key insights.
The stuff that sticks.
Yeah. So our goal today is simple. Distill the most important aspects of how administrative justice works in Turkey, all based on our source. We'll focus on the courts, their structure, what they actually do, and the core procedures involved.
Kind of like your express route to being well-informed on this.
Exactly.
And, while we're focusing on the process, the how of these disputes, it's worth remembering where they come from.
Right.
It's the substance of administrative law itself. We're talking like official decisions, government actions, contracts the administration makes. These are the things that spark a legal challenge in the first place.
Okay, so let's maybe set the scene a bit. Look at the history. Surprisingly, administrative justice as a formal system, it really took shape in France. But not initially as a way to limit the king's power, which is what you might expect.
No, it was more like a body for the king to consult with, almost to, rubber stamp his authority. It's kind of backwards from what we'd think, isn't it?
It is. Instead of a check on power, it was initially a tool to, bolster executive power. And this historical quirk, you could argue it's left some interesting legacies in how administrative law operates even today. Exactly. And here's where it gets really interesting. Over time, this French system, it evolved. It started to become a way for citizens to seek protection, compensation even, when they felt wronged by the administration.
Right. So it shifted.
Yeah, eventually it grew into this separate, independent branch of justice, totally distinct from the ordinary courts that deal with, disputes between individuals.
That evolution is just key. It shows how a system designed for one thing can adapt to serve a completely different purpose. Shifting from supporting state power to, safeguarding individual rights against the state.
Okay, let's bring the focus to Turkey now. The Council of State, or Dummies. Its story begins way back, Ottoman era, as Şure Devlet. Then through the Republic era, right up until 1982, actually. It was the single main court of appeal for administrative stuff.
Wow, the single one.
Yeah. Today, it's got this dual role. It acts as a court of first instance, so the first court hears some really important cases, and it's also a high court of appeal in many others.
The longevity, the changing roles, it just underscores how central and enduring the Council of State is in the Turkish legal system. It's been a constant through huge legal and political changes.
But its main job now, its primary function, is as that court of appeal.
Right.
It also has this less frequent advisory role. It gives its expert opinion on specific issues when the law says it has to.
Okay.
Currently, the Council of State is organized into 13 chambers, or DARE. And here's a really crucial detail to remember. Only the first chamber, Birinci DARE, deals with administrative matters in its administrative capacity, like giving advice.
Okay, so just the first chamber for that advisory.
Exactly. The other 12 chambers, they're primarily focused on judicial review, hearing appeals, making rulings.
So it's like one part helps the administration get things right beforehand, maybe through advice.
Yeah.
And the other parts are the referees when things potentially go wrong. And the specialization of those 12 judicial chambers, that's quite striking. Like you mentioned, the 6-chamber deals pretty much only with zoning plan disputes.
That's it. It's like having specialized departments in a really sophisticated organization, right? Yeah. Each chamber brings deep expertise to its own little area of administrative law.
Makes sense.
These chambers, they're typically made up of a president and 4 members. They make decisions by majority vote, sometimes unanimous. So it's a collective thing.
Yeah, that structure really emphasizes how complex modern administrative law is. You need that nuanced understanding in all these different fields. And having that collective judicial deliberation at such a high level must be valuable.
Let's dig a bit deeper into the Council of State's structure, how it actually operates day to day. Constitutionally, it's the Supreme Administrative Court. But it also serves as a crucial body for consultation and review. And fundamentally, it's independent.
Right. Independence is key.
The President of the Council of State, they handle the leadership, represented externally, and its members. A quarter are picked by the President of the Republic.
Okay.
And the other 3/4, they're chosen by the Council of Judges and Prosecutors.
That selection process is really interesting. It shows how both the executive and judicial branches are involved in shaping the highest administrative court. Kind of speaks to that intended balance of power within the system.
And just to be clear, the presidency of the Council of State also manages its internal affairs, especially things that connect with the executive branch, ensuring a smooth working relationship.
Makes sense.
Now, let's look at the key decision-making bodies within the council. First, those 13 chambers, the DARE we mentioned.
Right. First chamber administrative, others judicial.
Exactly. Each has a president, at least 4 members, need 5 for a quorum, decisions by majority. And crucially, there are also these examining judges, tetki hakimi. They do a lot of the prep work on cases.
The groundwork.
Yeah. And how's the workload divided? That's decided by the presidential board, Başkanı Kurulu.
This detailed breakdown, it shows that internal organization really designed for efficiency and specialization. That presidential board's role in managing case flow must be vital for the whole thing to work.
Then we have the Administrative Affairs Board Adari İşler Kurulu. Their main job, giving opinions on big concessions and contracts related to public services. Think like major infrastructure projects, essential utility deals.
So that advisory role, it kind of extends the council's influence beyond just settling disputes, doesn't it? It helps shape how the administration approaches these important public service agreements in the first place.
Next up, the Administrative Case Chambers Board Adari Dava Derelleri Kurulu. This is important. They act as the court of appeal for administrative cases that were initially heard directly by the Council of State itself.
Okay, so appeals from the council's own first instance cases.
Right. And they also handle appeals against something called insistence decisions israr karari from the regional administrative courts.
Ah, insistence decisions. What are those exactly?
That's when a lower appeal court, the regional administrative court, basically sticks to its original ruling, even after a chamber of the Council of State has expressed a contrary opinion or overturned it on a point of law.
So a sort of disagreement between the appeal levels.
Exactly. And this board resolves that. Plus, they can review and make final decisions on objections to stay of execution orders that were issued by the case chambers when they were acting as the first court. It's a critical check in the appeal process.
Yeah, that board sounds like it plays a vital role in ensuring consistency in how administrative law is applied, overseeing both the council's own initial decisions and those tricky insistence cases from the regional courts.
And similarly, there's the Tax Case Chambers Board Vergidava Derelleri Kurulu. Same idea, but purely for tax-related cases.
Makes sense. Tax law is specialized.
They handle appeals for tax cases first heard by the Council of State and appeals against those insistence decisions for the regional courts, but only in tax matters. And they also review objections to stay of execution decisions in tax cases at that first instance level.
That parallel structure for tax disputes really underscores how specialized tax law is and why you need a dedicated appellate body with that specific expertise.
We can't forget the big picture, though. The General Assembly of the Council of State, Danıştay Genel Kurulu. It's massive, made up of the president, the chief public prosecutor, the vice presidents, all the chamber presidents, all the members, and the secretary general.
Wow, pretty much everyone.
Yeah. Decisions there are also by majority vote.
So the General Assembly is like the ultimate collective authority within the Council of State. That broad membership ensures decisions reflect a really wide range of expertise and perspectives.
And finally, there's the Board for the Unification of Jurisprudence, İçi Hatları Birleştirme Kurulu. This is crucial for legal certainty.
Keeping things consistent.
Exactly. They step in when there are conflicting or inconsistent rulings coming from different chambers, or maybe between the administrative and tax case chambers boards, or even if there's just a feeling that established legal interpretations need a refresh. This happens when the president of the Council of State refers a case to them after getting the chief public prosecutor's opinion. If this board thinks it's necessary, they decide on unifying or changing the legal precedent. It's how consistency is maintained right at the top.
Yeah, this board is like the guardian of legal coherence for administrative justice, ironing out those inconsistencies, making sure the law is applied predictably across different cases and courts. Super important.
So, just to simplify, the Council of State primarily acts as the first and final court in certain specific, high-level administrative cases defined by law.
And it also has that expert advisory role for major public service agreement.
Exactly. Those dual roles, decision maker and expert advisor, really highlight the significant influence the Council of State has in Turkish public administration and law.
Yeah, it's clearly a very powerful and central institution.
Let's look at some actual examples of the types of cases heard directly by the Council of State as the initial court, like decisions made by the President of the Republic himself.
Okay, straight to the top.
Also covers regulatory actions issued by the president. But there's an important exception. Presidential decrees that have the force of law, those generally aren't included here.
Right, those probably have their own specific review mechanism, maybe constitutional review.
Probably. Then we have regulatory actions from ministries, other public institutions, or, professional organizations with public status, but only if these actions apply nationwide.
Ah, so it's about the scope. National impact means direct Council of State review. These examples give a real sense of the significance of the cases that bypass the lower courts, typically decisions with really broad impact.
We also see the Council of State getting involved in examining and deciding on requests about elected officials in municipalities and provincial administrations losing their official status.
Yeah.
So it's not just national regulations, it touches local governance too.
That jurisdiction over local government matters emphasizes the council's role in ensuring accountability and legal compliance, even down at the local level.
Now, what about its role as an appeal court? Well, final decisions from the administrative and tax courts, and also final decisions in cases that started in the Council of State itself, can all be reviewed by the Council of State on appeal.
Right. It's often the last stop in the legal process for these kinds of disputes. That appellate function is really the core of its judicial work, providing that crucial layer of review.
And it's important to remember, the specific chamber within the council, anywhere from the 2nd to the 13th, that handles the appeal from an administrative or tax court, that depends on the subject matter.
Back to that specialization we talked about.
Exactly. For cases that started in the Council of State, the appeal goes to either the Administrative Case Chambers Board or the Tax Case Chambers Board, again, depending on whether it's a general administrative case or a tax case.
It's quite an intricate system of appeals, isn't it? With specific chambers and boards assigned to different legal areas, really shows the depth and complexity of the Turkish administrative justice system.
We should also quickly mention how the workload is divided. Our source notes that various chambers, 2nd to 13th, and the Administrative and Tax Case Chambers Boards, they handle administrative disputes at both the initial and appellate levels. And there's also, a division of labor within the council for its purely administrative tasks.
That internal division of labor is essential, I imagine, for managing the sheer volume and variety of cases that must come before the Council of State. Ensures efficiency and that focused expertise in different areas.
All right, let's move down the judicial ladder now to the regional administrative courts, Bolje der Mahkemeleri, the administrative courts, Eder Mahkemeleri, and the tax courts, Vergi Mahkemeleri.
Okay, the next tier down.
These are all independent courts, general authorities set up for specific legal jobs. Interestingly, it's the Ministry of Justice that decides where they're set up and what their geographical areas are.
The Ministry of Justice decides that.
Yeah, and they look at the geography, the workload in different regions, and they consult with other ministries, Interior, Treasury, and Finance, Trade. So it's a coordinated government effort.
That centralized setup ensures some uniformity across the country, I suppose, and allows for adjustments based on regional needs.
Now let's focus on the administrative courts. They handle a really broad range of cases, specifically the ones that don't fall into the tax courts or the Council of State when it's acting as the first court.
So the default court for many administrative issues.
Pretty much. This includes annulment lawsuits, iptal davalari, where someone wants an administrative act canceled.
Right.
They also deal with full remedy lawsuits, tam yargı davalari, where people are seeking compensation for damages caused by administrative actions or decisions.
Okay, cancellation and compensation.
And they handle disputes from administrative contracts made for carrying out a public service. But there's an exception here. Disagreements about concession agreements and contracts that have arbitration clauses, those are usually handled differently.
The wide reach of these administrative courts makes them the primary place for most sort of everyday disputes between citizens and the administration at the local and regional level. Those exceptions help define their specific niche.
Turning to the tax courts, their focus is, well, pretty obvious, taxes.
Yep.
Fees, duties, similar financial obligations owed to the national budget, provincial administrations, municipalities, villages.
Yeah.
Includes interest, penalties, tariffs. So if you have a dispute with the tax authorities at any of these levels, this is generally where you'd end up.
That specialized jurisdiction makes sense. Tax law is notoriously complex, needs dedicated expertise.
Now, there's one more really crucial judicial body we need to cover. The Court of Jurisdictional Disputes, or Uyuşmazlık Mahkemesi.
Ah, the dispute court.
Kind of, yeah. It's a completely separate court. President, 6 regular members, 6 substitutes. And get this, the president is chosen by the Constitutional Court from among its own members.
Interesting link to the Constitutional Court.
And the decisions of this court's jurisdictional disputes, they are final, binding on all other judicial bodies.
Wow, final say.
With one tiny exception.
Mm-hmm.
If there's a jurisdictional disagreement between other courts and the Constitutional Court itself, then the Constitutional Court's decision wins out.
Okay.
So this court is basically the ultimate umpire when different parts of the legal system, like administrative versus regular courts, can't agree on who should hear a specific type of case.
Yeah, that sounds vital for maintaining order. Clearly defining the boundaries of authority for each branch of the courts and sorting out any conflicts.
Let's break down a key concept related to this court. The positive jurisdictional dispute, olumlu görev uyuşmazlığı.
Okay, what's that?
This happens when one court says, no, I do have jurisdiction, maybe rejects an objection saying it doesn't.
Right.
But another judicial system, say the regular courts, believes the case actually belongs to them. In that situation, the chief public prosecutor of the system that thinks it should have jurisdiction can ask the Court of Jurisdictional Disputes to step in and settle a matter.
Ah, so it's a mechanism to protect the established boundaries between the different judicial systems, like stop one court from overstepping.
Exactly. It ensures cases are heard in the correct type of court based on their nature.
Essential for preventing chaos, I'd imagine.
So how are these jurisdictional disagreements actually resolved in practice? Usually it's the plaintiff, the person who started the lawsuit, who kind of triggers the process if they get bounced between courts.
Okay.
The court that finally rules it doesn't have jurisdiction typically sends the whole case file over to the Court of Jurisdictional Disputes for a definitive ruling.
Right.
But, interestingly, a court can also send a case to this special court on its own initiative ex officio without anyone asking.
Proactive.
Yeah. And here's another scenario. Court A gets a case transferred from Court B because Court B said it lacked jurisdiction. But Court A also thinks it lacks jurisdiction and believes the case really belongs back with Court B.
Oh, a potential loop.
Exactly. So instead of just sending it back or ruling it lacks jurisdiction itself, Court A can send it directly to the Court of Jurisdictional Disputes to decide which of the two, A or B, is the right place. It avoids that endless back and forth.
Like sending it to the Central Resolution Team to stop the interdepartmental buck passing? That makes sense. This multi-layered process really shows the commitment to getting every case heard by the right court. Avoids cases falling through the cracks or being heard in the wrong system.
The Court of Jurisdictional Disputes also resolves something else, called a conflict of judgments, hukum uyuşmazlığı.
Conflict of judgments. Okay, what's that?
This occurs when you have at least 2 courts, and crucially, they have to be from different judicial systems in Turkey, administrative, regular judicial, or military.
Okay, different branches.
And they both reach final, conclusive decisions on the exact same issue, for the same reasons, involving at least one common party.
Right. Same case, different courts, different systems.
And here's the critical part. These conflicting judgments make it literally impossible to enforce the legal right in question. It's a complete legal stalemate created by the courts themselves.
Wow. That completely undermines the point of going to court, doesn't it? If you get 2 final answers that cancel each other out, the Court of Jurisdictional Disputes acts as the tiebreaker in these presumably rare but very significant situations.
Exactly. So what are the specific conditions for this conflict of judgments to exist? First, the judgments must come from two distinct judicial systems. Second, they need to be final decisions based on the merits, not just procedure.
Okay, final substantive rulings.
Third, they have to be about the same subject matter, same cause, and involve at least one identical party. And finally, the judgments must be so contradictory that enforcing the legal right becomes impossible. It's a pretty specific and high bar.
Yeah, those strict conditions ensure this court only steps in for truly irreconcilable conflicts between final judgments that directly block the enforcement of rights.
When this conflict does arise, the people involved, or sometimes the relevant government authority, can apply directly to the Court of Jurisdictional Disputes to sort it out. And in these cases, the court doesn't just say who should have decided. It actually looks at the conflicting judgments and makes its own WN decision on the underlying issue.
So it acts like a court of first and last instance in that specific situation.
Exactly. It breaks the logjam by providing a definitive resolution when different parts of the judiciary have reached completely opposite conclusions.
Powerful tool for resolving those rare but critical contradictions.
Okay, let's shift gears slightly. Let's talk about some fundamental principles guiding administrative justice in Turkey, based on our source. One key principle. When administrative actions are reviewed by courts, they look at both legality, did it follow the law, and appropriateness, was it reasonable and suitable?
That dual review is significant. It's not just checking if the administration could legally do something, but also if the way they did it was, sensible, fitting.
Another core principle. Administrative justice has a huge influence on shaping administrative law itself. Court decisions don't just apply existing rules, they actually help develop and clarify those rules over time.
Yeah, that dynamic relationship ensures the legal framework stays relevant and adapts to how public administration actually works in practice.
We also see the principle of ex officio investigation, resen araştırma ilkesi.
The court doing its own digging.
Exactly. Administrative courts can, and often do, conduct their own investigations into the facts. They don't just rely on what the parties give them.
That underscores the active role these courts play in finding all the necessary info to reach a just decision, even if the parties haven't explicitly provided it.
And of course, a fundamental principle is simply that administrative justice is responsible for resolving disputes between people, entities, and the administration. That's its main job.
Right.
And finally, it mostly operates through written proceedings, yazılı yargılama usulü. Most arguments and evidence are submitted in writing. Hearings can happen, but the written record is central.
That emphasis on written proceedings allows for a really detailed, documented review. But having the option for hearings ensures parties still get that chance for oral presentation if needed.
Now, our source has a review question that flags something important about the Council of State's duties. It asks which of these is not one of its jobs. The options are conducting Dummies, final appeal reviews, providing advisory opinions, reviewing regulations, tuzukları incelemek, deciding some cases first, and conducting istinaf reviews.
Okay, so Dummies is the final appeal. Istinaf is the regional appeal.
Right, and the answer is conducting istinaf reviews. That's the job of the regional administrative courts, not the Council of State. It highlights that hierarchy.
Yeah, clarifies the different levels of appeal. Istinaf is the first layer of appeal for most cases, handled regionally.
Another review question points out that the principle that there is no judgment without a hearing, duruşmasız yargılama olmaz ilkesi, is actually not a fundamental principle of administrative procedure in Turkey.
Which might surprise some people based on other legal systems.
Exactly. The actual principles listed as options were written proceedings, review of the file, and ex officio investigation. This just reinforces how central the written submissions and the court's own fact-finding are.
Yeah, highlights a key difference in emphasis compared to systems where oral arguments might dominate. Here, the written record and the court's inquiries are paramount.
And lastly, it's crucial to understand that judicial review in administrative law ensures the legality of administrative actions. But this review isn't automatic. It follows specific procedures. Also, importantly, and contrary to a false statement in our sources' examples, this review generally does not extend to judging the appropriateness, juridic, of the action.
Right. Courts usually won't second-guess policy choices if they're within the law.
And it's also vital to remember that some specific types of administrative decisions are indeed not subject to judicial review at all, though these exceptions are usually pretty limited.
That distinction between legality and appropriateness reflects a separation of powers, right? Courts defer to the executive's policy decisions as long as they're legally sound.
Let's talk about the general rules for jurisdiction. Which court system and venue which specific court. Article 32 of the Administrative Judicial Procedure Law sets the general rule for venue. If no specific court is named elsewhere, the authorized court is the administrative court in the same jurisdiction as the administrative authority that issued the act or signed the contract.
So generally where the government action originated makes logical sense as a starting point, connects the case directly to the source of the decision.
But here's an interesting twist. This rule in Article 32, it actually does double duty. It sets the general venue rule, and it establishes a fundamental aspect of general jurisdiction. If an administrative dispute doesn't belong in the regular courts or the council of state or the tax courts, then the administrative court in the place where the administrative action happened is the competent one. It acts like a default for administrative disputes that don't fit neatly elsewhere.
Ah, okay, so that dual function underscores the really broad scope of administrative court jurisdiction for handling disputes involving state actions.
Now, there are some important exceptions, things administrative courts cannot hear. Our source lists several. Core legislative actions of the parliament, like passing laws.
Makes sense, separation of powers.
But there's an exception to the exception. Decisions by the Speaker of Parliament about the Parliament's own staff are considered administrative acts and can be challenged in administrative courts.
Interesting. So even within the legislature, their administrative actions as an employer are still subject to administrative review. It's about the nature of the action.
Exactly. Similarly, core judicial actions of the regular courts are out. But again, an exception. Decisions by a court president about their court staff can be challenged administratively.
Again, reinforcing that administrative law deals mainly with executive actions and the administrative functions of other branches, not their core judicial or legislative roles.
There are also specific rules for lawsuits against public officials. Generally, if an official's negligence causes harm while they're on the job, claims for compensation go against the administration itself in administrative courts.
Okay, sue the employer, not the employee usually.
Right. The one big exception is if an official intentionally refuses to follow a court order. In that specific case, claims for damages against that official go to the regular judicial courts.
Ah, intentional defiance is different.
And interestingly, if the administration does pay damages because of an official's actions, they always file a separate lawsuit, a recourse suit, rukadavaza, against that official in the regular judicial courts to try and get the money back.
So the administration is generally responsible, but can seek reimbursement from the official in cases of intentional wrongdoing or maybe gross negligence. That's an intricate system of liability.
Our source also notes that lawsuits challenging administrative penalties under the misdemeanors, law kabahatler kanunu, usually go to regular judicial courts, unless another law specifically says otherwise.
Okay, so a specific pathway for those less serious infractions, typically outside the administrative system.
Then there are lawsuits about contracts, where the administration is a party, but the contract itself is governed by private law principles.
Right, like a standard supply contract.
Those go to regular civil courts, not administrative courts. It depends on the law governing the agreement.
Crucial distinction. If the government acts under the same rules as private individuals in a contract, disputes follow those private law rules.
Lawsuits filed by the administration against private individuals.
Yeah.
Also generally not in administrative courts.
Unless
the lawsuit arises specifically from an administrative contract. So when the government is suing a private party outside that specific context, they typically use the regular court system.
Makes sense. Administrative courts are mainly for challenges against the state, not usually the state suing others in a more private capacity.
We also see that lawsuits trying to cancel commitment letters, tahud name, or surety bonds, kefalet senet Larry, given to the administration, are not under administrative jurisdiction, seen more as private law obligations.
Okay, financial instruments generally governed by private law.
Lawsuits about a former owner's right to buy back expropriated property, Jerry Almahaka, also outside administrative jurisdiction, handled under property law procedures.
Right, specific rules for expropriation.
And finally, lawsuits to correct population records, nüfus kayıtlarında, düzeltme yapılmasına ilişkin davalar, typically dealt with in regular civil courts, matters of personal status.
Personal status, official records, usually civil law territory.
Okay, let's circle back to those specific cases heard directly by the Council of State as the court of first instance. Article 24 of the Council of State law lists some, other laws add more. We mentioned presidential decrees, excluding those with force of law, and nationwide regulations from ministries, etc.
Right, the high-level stuff with broad impact.
But there's more. Administrative lawsuits related to privatization practices also heard first instance in the Council of State under specific privatization laws.
Underscores the importance of judicial oversight in those major economic shifts. Privatization can be complex, legally and economically, so direct review makes sense.
Our source also points out lawsuits against decisions by the Ministry of Energy and Natural Resources affecting rights under the Turkish petroleum law. Things like exploration permits, drilling licenses, those go straight to the Council of State, too.
Energy sector decisions. Huge economic and strategic implications. Warrants the direct high-level scrutiny.
And finally, annulment lawsuits against decisions by the president or a minister to ban a news item or broadcast when it's supposedly required by national security under the radio and TV law. Those also go to the Council of State first.
That's a sensitive area, isn't it? Freedom of expression versus national security. Makes sense for the highest administrative court to handle those directly.
Now, let's really nail down the difference between jurisdiction Gurev and venue Yetki. Jurisdiction is about which court system is right. Venue is about which specific court within that system.
Like hospital system versus specific hospital.
Exactly. Our source uses this example. If a dispute belongs in administrative courts generally, the Gurevli court system is administrative court. But the Yetkili court, the venue, might be, say, the Istanbul Administrative Court, if that's the right location based on the venue rules.
Okay, jurisdiction, type of court, venue, location of court. Fundamental distinction.
And here's a really crucial point from Article 32 of the law. In administrative procedure, all rules about venue are considered matters of public order kamu düzeni.
Public order. What does that mean practically?
It means it's fundamental. The courts can, and often will, raise venue issues themselves, even if the parties don't. It's seen as vital for ensuring cases are heard in the right place for justice to be properly administered. You can't just agree with the other side to have it heard somewhere else if the rules say otherwise.
So it's not just a procedural convenience for the parties. It's seen as essential for the system's integrity. That classification as public order underscores its importance. Allows courts to proactively fix venue issues.
Now let's talk about special venue rules, Uzoyetki. For disputes about immovable property land, buildings, Article 34 says the authorized court is where the property is located.
Makes intuitive sense. Court closest to the physical dispute.
Right. Examples include zoning plans, expropriation, licenses, demolition orders, occupancy permits, and the Council of State has interpreted related to immovable property pretty broadly. It includes things like tourism operation certificates, land allocation, building registrations, conservation areas, even workplace closures and dealership licenses. It's a wide net.
That special venue rule ensures disputes are resolved by courts familiar with the local context and the potential impact on the land itself.
The source gives great illustration. A dispute about land allocation for tourism in Muğla. The company suing is in Istanbul. The ministry that decided is in Ankara. Where's the venue?
Muğla, right, because that's where the land is.
Exactly.
But
not Istanbul or Ankara. The property location rules.
that clearly shows how the special venue rule for property overrides the general rules based on where the administration or plaintiff is located.
Article 34 also has special rules for cases concerning villages, municipalities, special provincial administrations, and border disputes. Specifically for border disputes like setting or changing borders or annexing an area to a new province, there's an optional venue, seçimlik yetki.
Optional, meaning the plaintiff chooses.
Yeah. They can file either in the administrative court, where the unit is currently located, or R, where it's been newly annexed. Provides flexibility in those local government disputes.
That optional venue acknowledges the strong local interests and the convenience of having the case heard in the area directly affected.
Moving on to movable property, things you can move. Article 35 says the authorized court is where the property is located.
Okay, but movable property moves. How does that work?
Good question. The Council of State has applied this to things like requisition, in Istanbul allocation, refusal of import permits, confiscation. But our source includes commentary questioning the logic. Why tie a dispute about something mobile to a specific physical location at a specific time?
Yeah, the rationale is less obvious than for land. Maybe it's just to provide a concrete venue, but it could seem a bit arbitrary in practice.
For cases not covered by the special rules for immovable or movable property, Article 36C gives us a general fallback venue rule, Geneltali Yetki Kuralır. In these other cases, Diderhaller, the authorized court is where the plaintiff resides.
The plaintiff's home turf as the default.
Yeah. The source suggests other cases could be situations other than typical administrative actions, or maybe where the other venue rules just aren't feasible.
Like a safety net ensures there's always somewhere to file.
An example given is damages from administrative actions that happened abroad. The court where the plaintiff resides in Turkey would be the competent venue under this rule.
Okay, that makes sense for overseas incidents.
It also clarifies that in situations where the right to file an annulment suit is temporarily suspended, like during a state of emergency,
Right.
the competent court is probably better determined by the rule based on the location of the administrative body that took the action, rather than the plaintiff's residence. The focus shifts to the source of the administrative activity.
That clarification is important. Shows the fallback rule is applied thoughtfully, considering the specific circumstances and the broader legal context.
Now, what if a court realizes it took a case it shouldn't have, lacks jurisdiction, and transfers it? Provisional Article 7 outlines this. If the Council of State gets a case transferred to it, but it also thinks it lacks jurisdiction, it will send it on to the court it deems competent and authorized.
Like legal hot potato until it lands in the right place, ensures cases aren't just dismissed due to initial errors, but get directed properly, prevents denial of justice.
And what if a court receives a transferred case, but it also thinks it's the wrong court? If both courts are under the same regional administrative court, that regional court decides between them.
Okay, regional umpire.
But if the two courts are in different regional court areas, then the Council of State makes the final call. And these decisions by the Council of State or regional courts on jurisdiction and venue are final. No more appeals on that specific point.
That hierarchical mechanism provides a definitive answer on which court hears the case, avoids prolonged uncertainty and delays.
Article 39 further clarifies this process for deciding the competent court when there are disagreements. If the dispute is between courts in the same judicial district, the case goes to the regional administrative court for that district. In all other situations, it goes up to the Council of State. They determine the competent and authorized court, and again, their decision is final.
This formalizes that process of Mircea designation of authority, provides a clear procedure, especially if public order is affected or multiple courts could potentially be competent.
Okay, let's get practical now. Starting an administrative lawsuit. How do you prepare the petition? What must be in it? Where do you submit it? Can you challenge multiple actions at once, or can several people file together? And what are the basic types of lawsuits?
Understanding these foundational procedures is absolutely essential. Get these wrong and you face delays or even dismissal.
Article 3 of the law is very clear on what must be in the petition. First, addressed to the right court, presidency, Council of State, administrative or tax court, and signed.
Okay, basic formalities.
Then, full names or titles, complete addresses of all parties, including lawyers. And for individuals, your Turkish Republic ID number.
Identifying everyone involved.
You need to state the subject of the lawsuit, the legal grounds for your claim, and the supporting evidence you have.
What you're suing about, why, and what proof you have.
Crucially, the date you were officially notified in writing of the administrative action you're challenging. That starts the clock, often.
Right. The notification date is key for deadlines.
These initial requirements ensure the court has the basics. Who's involved? What's the dispute? When did it happen? And what's the plaintiff's argument and evidence?
Laying the groundwork for the case.
Now, if your lawsuit involves money taxes, fees, penalties, or RR, if it's a full remedy lawsuit seeking compensation, you must specify the exact amount you're claiming.
Gotta state the figure.
In tax lawsuits specifically, you also need the type and year of the tax penalty, the date and number of the tax assessment notice, IBAR name, and your taxpayer account number, if any.
Specific details for tax cases.
Finally, you have to attach the original or clear copies of the decision you're challenging, plus relevant documents, and enough copies of everything for each opposing party, plus one extra for the court.
Documentation and copies are vital. These extra requirements for financial tax cases ensure the court has the specific details needed.
Our source even gives a sort of template structure for a petition. Describe the challenged action, date, number, subject. Explain how it violated your rights interests. Claim damages, if applicable. State why you're suing. List the legal grounds, laws, regulations. List your evidence, documents, experts, etc. And conclude with your demand what you want the court to do.
Right.
Often including a request for stay of execution and ultimately annulment of the action and maybe compensation. A comprehensive legal argument.
That structured format makes the petition clear, organized, legally sound. easier for the court and the other side to understand the claim and what's being asked for.
Now, where can you actually submit this petition? Article 4 gives options. Directly to the Presidency of the Council of State, or the relevant court,
Yeah.
or to the Presidency of the Administrative or Tax Court, and they have to forward it.
Okay, flexible submission points.
Even in places without these courts, you can submit to the local civil court of first instance as Sli Hukuk Hakim Likleri, and if you're abroad, a Turkish consulate. Not an embassy, a consulate.
Multiple options to ensure access, regardless of location, even outside Turkey.
And here's a really important point. The official date you submit the petition to any of these designated places is considered the date the lawsuit is filed. Crucial for deadlines.
Right.
So if the Ankara court is the right venue, but you file in Istanbul, it's considered filed on time from the moment Istanbul receives it.
That protects people from penalties for submitting to the wrong designated point in good faith.
Our source also details the procedure. If you submit to the wrong court, if there is an administrative or tax court in that location, give it to them. If not, give it to the civil court of first instance. If you give it to a civil court when an administrative court does exist there, it's considered filed when the administrative court actually receives it. Again, abroad, it's consulates.
These specific procedures aim to streamline handling misdirected petitions, ensuring they get to the right place without undue delay or prejudice.
Let's talk about consolidating related cases, Bolantili Dava. Article 40 covers this. What happens when multiple separate lawsuits are filed in different administrative courts, but they're all about the same underlying issue?
Makes sense to consolidate, avoids duplication, inconsistent rulings.
When this happens, the regional administrative court steps in. They review the related files urgently. If they decide there is a connection, they order the file sent to the court they deem most appropriate to hear them all together. The other courts are informed, and the designated court notifies all the parties.
So the regional court acts as the coordinator, ensuring a unified approach to interconnected litigation within its area.
But if the regional court looks and decides there's no real connection,
Then the files go back to their original courts, and the lawsuits proceed separately. Respects the autonomy of individual cases where there's no significant overlap.
okay, let's talk about the different fundamental types of administrative lawsuits in Turkey. Our source says the primary ones are annulment lawsuits, iptal davaları, and full remedy lawsuits, tam yargı davaları, listed right in Article 2 of the law.
The main two categories.
Yeah. While you might think of others like declaratory or performance lawsuits, in the administrative context, they're generally pursued within the framework of annulment or full remedy actions,
Yeah.
not usually seen as standalone categories.
So that clear categorization simplifies things. Annulment and full remedy are the main tools for challenging administrative actions and seeking compensation.
Our source draws an interesting comparison with France again. There, if a court faces a really tough case, it can pause and ask the Conseil d'État for an advisory opinion, avis contentieux, to help clarify things.
Right.
But that's not possible in the Turkish system.
Yeah.
Seen as potentially conflicting with principles like the natural judge and judicial independence. Each Turkish court makes its own call.
That difference highlights distinct approaches. The Turkish system emphasizes the individual court's responsibility and autonomy in resolving cases.
Now, Article 2C mentions lawsuits arising from administrative contracts. İdari Sözleşme Kaynaklarından Davalar. Might sound like a third type, right?
Yeah, it's like it.
But legal experts generally interpret this as referring to annulment or full remedy lawsuits that just happen to originate from an administrative contract. Not really a separate category, more context.
Oh, okay. So if you think an administrative contract is illegal, you file for annulment. If you suffered loss due to a breach, you file for full remedy. The contract is the source, but the lawsuit type is still one of the main two. That interpretation clarifies things.
Our source has a review question asking which option is not a type of lawsuit in administrative jurisdiction. Options were performance lawsuit, edim davası, declaratory lawsuit, cizbek davası, action for prevention of interference, benim davası, claim lawsuit, istikak davası, and full remedy lawsuit, tam yargı davası.
And the answer?
Full remedy is a type. The others listed are generally not considered distinct categories of administrative lawsuits in Turkey. They might fit within annulment or full remedy, but don't stand alone.
Reinforces the focus on annulment and full remedy as the main legal avenues.
Let's dig into annulment lawsuits. Our source says they're objective lawsuits concerned with legality and public order, not just individual rights.
Right.
The subject is always specific administrative actions, but only those whose direct interests are violated can file. And contrary to a wrong option in the source, you can file annulment against administrative accusations. Idoria Lemler, not just formal acts. The goal: get an illegal administrative act canceled.
The objective nature highlights their role in upholding the rule of law, and the violated interest requirement ensures the plaintiff has a concrete stake.
Now, full remedy lawsuits, different beast. They're subjective, focus on protecting the specific rights of the person suing.
Okay.
Only those whose rights were directly violated can file. They typically seek compensation, financial, emotional damages resulting from administrative action or act.
Right, making the injured party whole.
And contrary to some false statements in the source's examples, they are not filed against all administrative acts, nor do they only arise from administrative actions. They can be based on both formal acts and general actions that cause direct harm.
So, if the administration does something unlawful, a decision or an action, and you suffer measurable harm, full remedy is how you seek compensation. It serves as that crucial mechanism for individuals to get redress for specific harm from unlawful administrative conduct.
Our source clearly states that the requirements for who can be a plaintiff differ between annulment and full remedy suits, according to Article 2. For annulment, the criteria are broader.
Which makes sense given their objective nature and potentially wider impact. An illegal act could harm many people, or the public interest generally.
Exactly. The broader standing reflects that public interest in ensuring legality.
Whereas for full remedy lawsuits, the right to sue is more restricted, generally limited to those whose rights were directly and demonstrably violated.
Right. Since it's mostly about compensation for specific harm, it's logical only those who actually suffered that direct damage can sue for it.
The narrower standing aligns with their subjective nature, focusing on compensating individuals for concrete damages they incurred.
Our source gives a really interesting example of potential plaintiffs and defendants. It mentions the Cultural Heritage Preservation Board's Kulturvarlıklarına Koruma Kurulları, operating under the Ministry of Culture and Tourism.
Okay.
Even though these boards don't have separate legal personality from the ministry, they can make independent decisions about cultural heritage. And the ministry itself can't administratively overrule these decisions.
So they're independent decision makers within the ministry structure.
Seems like it. So disputes can arise between the ministry and these boards, which can lead to litigation. And here's the weird part. In such cases, the Ministry of Culture and Tourism can act as both plaintiff and defendant in the same lawsuit, representing both sides.
Wow, that is unusual, essentially suing itself.
Kind of. It arises from the specific legal setup of these boards and their relationship with the ministry. Just shows how nuanced legal standing can be in administrative law. The traditional lines can blur.
That's a fascinating example of how specific organizational structures can create unique legal situations.
Okay, let's talk consequences. What if there are errors or missing info in your lawsuit petition? Articles 3, 15, and 30 cover this. If your petition doesn't have all the required info from Article 3, or if you filed without proper legal standing or against the wrong government body.
Right, procedural mistakes.
The court notifies you and gives you a strict 30-day deadline to fix it. Fail to fix it in time, your lawsuit could be dismissed. So getting the initial petition right is vital.
Those rules ensure lawsuits are properly formulated and directed, promotes efficiency, and that 30-day period gives a chance to fix minor oversights without immediate dismissal.
There are rules for other situations, too. If a petition is filed about someone already deceased, it's canceled. If court notifications to your address keep bouncing back,
Undeliverable.
the case file gets temporarily removed from proceedings until you provide a new address. Any stay of execution order becomes void. And if you don't provide a new address or ask for reactivation within 1 year, the lawsuit is considered never filed. Serious consequences for not keeping contact info current.
These provisions tackle practical problems that can disrupt a lawsuit, aim to maintain efficiency and integrity.
Importantly, decisions to put a case on hold or deem it never filed are officially communicated to the other party. Ensures transparency.
Right, keeps the defendant administration informed about procedural issues affecting the case status.
Our source also mentions you can ask the court to correct certain types of errors in their decisions, under Article 30. Mistakes in names, titles, the stated outcome, or simple arithmetic errors in the judgment.
Allows fixing obvious mistakes without a full appeal. Efficient rectification of clear, clerical, or calculation errors.
Finally, for procedural stuff not specifically covered in the Administrative Judicial Procedure Law, Article 31 points us to the Civil Procedure Law, HMK. Covers things like legal capacity, third-party intervention, notification, representatives, waiver, acceptance.
So the HMK fills in the gaps.
But with one key difference highlighted. The formal notification of the lawsuit to the defendant is done ex officio by the court's own initiative in administrative cases, according to Article 31.
Ah, okay. So while civil rules apply generally, specific administrative procedures like ex officio notification exist. That referral ensures a comprehensive rule set while recognizing the distinct nature of administrative disputes.
Article 24A requires the names, titles, and addresses of parties to be in the court's final decision, mainly to establish who's bound by it.
And this info is also required in the initial petition along with the ID number.
Right. Article 30 then provides that mechanism for correcting errors in this identifying info in the judgment. Misspelled name, calculation error in the award amount. You can apply to the court that made the decision to get it fixed without a whole new trial. Courts apparently do this quite often.
Yeah, that mechanism promotes accuracy and efficiency, allows fixing clear mistakes without relitigating the whole thing.
Our source includes a review question about the legal standing of associations der Neckler. The correct answer. They can file lawsuits against administrative actions related to their stated purposes and activities, and which affect the rights and interests of their members.
So their standing is tied to their mission and their members' well-being, not unlimited.
Exactly. Incorrect options were things like filing any suit related to their aims, or not needing a personal interest, or filing all suits related to workers.
Clarifies that association standing must be clearly linked to their objectives and who they represent.
Another question. Which entity cannot be a defendant? Options: university, municipality, faculty, governorate, ministry.
And the answer is
Faculty. While a university, municipality, governorate, ministry are public legal entities that can be sued, a faculty is usually seen as part of the university, lacking separate legal standing to be sued independently.
important distinction for knowing who to hold accountable. Defendant must generally be a public legal entity with independent administrative authority.
Finally, regarding intervention in a lawsuit via Mudahal, the correct statement from a review question is that intervention is possible at every stage of the lawsuit.
Meaning, if you have a legit legal interest in an ongoing case between others, you can ask to join as an intervener anytime before the final judgment. Ensures all parties with a real stake can participate.
Okay, what if you try to resolve things with the admin body before suing? Article 10 covers this. If you make a formal written application asking them to reconsider, revoke, amend, etc.
Right, within the original lawsuit filing deadline.
And the administration doesn't respond within 60 days. Your request is legally considered rejected. Implied rejection, Zimni read. If you then sue, the legal basis is actually the annulment of this implied rejection that occurred after 60 days of silence.
So the administration's inaction triggers a pathway to court, incentivizes them to respond promptly.
Our source also discusses specifying the amount claimed in full remedy lawsuits. Sometimes stating an exact figure initially is impossible, right? Like lost wages for a dismissed civil servant, the amount keeps growing.
Yeah, how do you handle that?
The Council of State says it's enough if the claimed amount is described in a way that's calculable later. A specific fixed amount isn't always mandatory up front.
Okay.
For example, I request all financial rights I've been deprived of until the decision as material compensation. But you can't be totally vague. You must either state the amount, clearly describe the damages, or at least provide enough info for the court to figure out the action and its consequences.
That flexibility acknowledges the difficulty in precise quantification early on, while still ensuring the court understands the scope of the compensation sought.
When the court actually examines the merits of a full remedy lawsuit, your claim for compensation, our source says the administration's liability rests on two main principles: fault-based liability, and no-fault liability.
Okay, fault and no fault. These are the legal grounds for the court's judgment on compensation.
Let's look closer at no-fault liability. This can arise even if the administration wasn't negligent or directly at fault. It's based on the idea that in certain situations, the administration is still responsible for harm resulting from its activities or broader societal risks.
Examples.
Liability in hazardous activities, like operating a nuclear plant. Liability from terrorist events, where the state might support victims even if not directly involved. And the principle of equality before public burdens.
Equality before public burdens.
Yeah, the idea that if one person or a small group bears a disproportionately heavy burden for the public good, they might be entitled to compensation from the state to ensure fairness.
Interesting. So these examples show liability arising not from wrongdoing, but from the nature of state actions, managing societal risks, or ensuring fairness in distributing burdens.
We've covered a lot. Let's use some review questions from the source to cement these ideas. First, define the subject of annulment lawsuits. Iptal davalare.
Legal actions challenging the legality of specific administrative actions by government bodies, focused on whether the action was lawful.
Good. List characteristics of an executive administrative act, ikrai idari ishlam.
Official actions that directly affect legal right status and are capable of being implemented has a tangible, immediate impact.
List and briefly explain the grounds for the administration's liability.
Two main ones. Fault-based liability, kusur sorumluluk, harm caused by negligence or failure in duties, and no-fault liability, kusur sorumluluk, applies in specific situations like hazardous activities or social risks, terrorism, even without direct admin fault.
What aspects of administrative actions are reviewed for legality in terms of content?
Whether the admin body had legal authority, competence, acted for a legitimate public purpose, and whether the subject matter itself complied with the law, basically. Could they do it? Why did they do it? And was what they did legally okay?
And explain the concept of social risk. Social risk.
Falls under no-fault liability. States' potential responsibility to compensate for harm from broad societal threats like terrorism. Rationale is the state's general duty to protect citizens, leading to potential redress even if specific prevention failed.
Okay, more review questions on actions and liability, which cannot be the subject of a lawsuit. Disciplinary penalties, appointments, admin contracts, tenders, or preparatory actions.
Preparatory actions. Those entreaty steps before a final decision usually aren't challengeable until they result in a concrete, legally effective act. Prevents courts being flooded with challenges to preliminary steps.
Which is not a fundamental element of an administrative action.
Yeah.
Competence, shaki, fault, kusur, form, shekel, subject, konu, or purpose, maksat.
Fault, kusud. Fault is about liability for damages, not a defining element of the action itself. The elements are about legality, authority, procedure, content, purpose.
Regarding fault-based liability, which statement is correct, it's based on service fault, hizmet kusuru, and arises from poor functioning of the service. Hizmetin kotu işlemesinin kaynaklanır.
Right. Negligence or general failure of the service is enough. Doesn't require intentional harm.
Which is not a ground for no-fault liability.
Right.
Responsibility for a third party's action, çünkü kişinin ediminden sorumluluk, hazardous activities, terrorist events, social risk, equality before public burdens.
Responsibility for a third party's action. Generally, admin is liable for its OWN action services, not automatically for unrelated third parties. No fault applies in specific situations defined by law.
Finally, an incorrect statement presented is, an annulment lawsuit can be filed against all decisions taken by the administration.
False. We know some decisions are excluded from review.
Correct statements included. Judicial review ensures legality. Admin can have fault liability without intent. Illegality of one element is enough for annulment, and the subject of an annulment suit is the request for annulment.
Good summary. Reinforces the scope and limits of review, basis for liability, and the aim of annulment suits.
Now, a critical practical aspect. Time limits for filing lawsuits. Articles 7 and 8 of the law are key here. General deadline. 60 days in the Council of State and Administrative Courts.
And shorter in tax courts.
Right, 30 days in tax courts. Unless specific laws say otherwise for particular cases. These deadlines are strict.
Crucial for legal certainty. Prevents indefinite challenges. The shorter tax period likely reflects the need for timely resolution of financial matters.
How are these limits calculated? For general administrative disputes, the clock starts from the date of written notification of the challenged action.
Okay, from notification.
For taxes, fees, duties, etc., it's more specific. Depends how the obligation arises. If contingent on collection, from collection date. If there's a notification, from notification date.
Yeah.
Withholding taxes, from date payment is made. Registration taxes, from registration date. If the administration itself needs to sue, from when the relevant decision reaches them.
Those specific rules for tax timing make sense, reflecting the different ways tax obligations arise and are communicated.
Let's focus on annulment suits against administrative acts. When does the clock start? Day after notification is day 1.
Okay.
Weekends and holidays are included in the count. But if the very last day falls on a weekend or official holiday, the deadline extends to the end of the next working day.
Practical safeguard. Ensures a full chance to file even if the deadline hits a non-working day.
Now, Article 11, suspension of the filing period. This is really important. Before you sue, you can apply to the higher administrative authority, or the issuing one if no higher authority, asking them to revoke, withdraw, amend, or issue a new action.
Right, trying internal resolution first.
You must do this within the original lawsuit filing deadline. If you do, it temporarily stops the clock on the lawsuit deadline while they consider your request.
Encourages using administrative channels first, potentially quicker, less costly resolutions.
So what happens after you apply for reconsideration? If your application is rejected, or if you get no response within 60 days.
The implied rejection, zimnia.
Then, the remaining portion of the original filing period starts running again from the day after notification of rejection, or the day after the 60-day silence period ends. If it was implied rejection, no response in 60 days, you actually get the full original filing period, usually 60 days, starting from the day after the silence period ended.
Ensures people who try admin channels aren't penalized by time passing and still have their right to sue if unsuccessful.
Let's turn to time limits for full remedy lawsuits seeking compensation for harm from administrative actions. Article 12 says generally file within 60 days after written notification of the damage-causing action, or within 60 days from when you learned of the damage and the responsible party.
Okay, 60 days from notification or awareness.
But there's an overall limit. Even if the harmful action was much earlier, you can still file within 10 years from the original date of the harmful action. That's the ultimate cutoff.
Balances timely claims with recognizing it might take time to realize harm and its source. The 10-year limit provides finality.
Interestingly, our source highlights the Council of State often interprets the start of that 60-day period as date of learning the damage and the perpetrator, even if the law's wording is slightly different.
To prevent loss of rights if awareness wasn't immediate.
Exactly. This broad interpretation, sometimes justified by an intolerability criterion, can allow suits even 10-15 years later, prioritizing fairness over strict wording.
Shows how judicial interpretation shapes practical application, sometimes expanding rights beyond strict text for fairer outcomes.
Finally, Article 8, Paragraph 3 deals with the judicial recess, July 20th to August 31st.
The summer break for courts.
If the end of a filing deadline falls during this recess, the deadline is automatically extended by 7 days, starting from September 1st, the day after recess ends.
Ensures deadlines falling during the break don't prejudice legal rights. Practical adjustment for court operations.
Quick review on time limits. General filing period in administrative cases.
60 days in Council of State and administrative courts. 30 in tax courts generally.
When does the filing period stop running?
When you apply to the admin authority for reconsideration, revocation, withdrawal, amendment, etc. within the original deadline.
Basic principles for calculating time limits.
Starts day after notification. Weekends, holidays count, but deadline extends if last day is non-working. Stops upon application for admin reconsideration.
Examples of special filing periods.
30 days in tax courts is the main one. Specific laws might set others. Always check relevant legislation.
Start filing period in full remedy suits for actions and acts.
For ACTS causing harm, day after notification. For general actions causing harm, date of learning damage, and responsible party, within the overall 10-year limit from the action date.
Okay, once you've filed your petition, what's the very first thing the court does? Articles 14 and 15 cover the initial review ilk in Selim.
The first hurdle.
Its aim is to check fundamental procedural requirements. Are there obvious deficiencies? Formal errors? Is the subject matter even something admin courts can hear? They check the filer's identity if the issue affects the plaintiff, if it's a suable matter, if the petition is complete.
Right. Is this case properly before the court?
To speed things up, the court can reject the petition at this stage for fundamental flaws, maybe giving 30 days to fix curable issues, sometimes without even notifying the other side yet. Helps weed out unfounded claims or identify fraud quickly.
Acts as a crucial filter. Ensures only properly prepared, potentially valid suits proceed. Saves time and resources.
Article 14, Paragraph 3 lists exactly what's checked. Jurisdiction, jäv, venue, yetki, exceeding administrative authority, idare mershi tekavuzu. Legal standing, iliet. Is it a definitive and enforceable admin action? Time limit exceeded, sir ashman. Proper defendant, husumet. And compliance with petition requirements, Articles 3 and 5.
A comprehensive checklist of fundamental prerequisites addresses potential major issues right at the start.
If the petition fails on any of these, a report goes to the chamber or court. Unless it's a single judge case, then they apply Article 15 directly. This whole initial review must be done within 15 days of receiving the petition.
That 15-day time frame emphasizes the goal of quick screening. Efficiently moves forward cases that meet basic standards.
Article 15, Paragraph 1 lists the decisions after this review. They can reject the petition if court lacks jurisdiction venue, admin exceeded authority, plaintiff lacks standing, Action isn't defended enforceable, time limit exceeded, wrong defendant, though here they usually notify to correct the defendant.
Okay, various grounds for rejection.
Or, if the petition doesn't meet formal requirements, Articles 35, they usually grant 30 days to resubmit corrected. Same if a non-lawyer filed improperly for someone else.
Opportunity to fix formal errors.
Finally, the court can refer the petition to the competent administrative authority if the issue actually belongs there, not in court.
Directing it to the right place. These varied outcomes provide tailored responses to different deficiencies, from rejection to correction opportunities to referral.
If your petition is referred to the admin authority, the date you first filed with the court counts as your application date to the authority. No time lost.
Good to know.
No extra fee if you resubmit after rejection for formal errors under Article 3. But importantly, most first examination decisions, except rejection for lack of jurisdiction venue, directing to correct defendant, or rejection allowing resubmission, can be appealed via istinaf or temias.
So some initial decisions are appealable.
But if you resubmit after rejection for formal errors and the resubmitted version has the same errors, lawsuit dismissed, no more chances.
Fair enough. These rules clarify consequences, appeal routes, and the outcome of resubmissions.
Our source mentions a practical checklist often used first. Fees paid, postal expenses covered, bar association stamp, request for stay of execution, hearing request, evidence discovery request. Only after these admin checks does the detailed legal review under Article 14.3 happen.
Ensures basic admin prerequisites are met before the deeper legal review.
The source also notes a schema exists, summarizing this whole first examination process, subjects, decisions, appeal routes. Can be very helpful visually.
Yeah, flowcharts are great for complex procedures.
There's also a specific provision. If a suit belonging in administrative court is mistakenly filed in regular judicial court and dismissed there for lack of jurisdiction.
Right, filed in the wrong system.
You get a special 30-day window from when that dismissal becomes final to file an NW suit in the correct administrative court. And the date you first filed in the wrong court counts as your filing date for the administrative court.
Valuable safeguard. Mitigates losing your right to sue due to an initial good faith error in choosing the court system if you act quickly.
Let's revisit that requirement. The challenged action must be a definitive and enforceable administrative act. İdari davaya konu olan herkesin ve yürütülebilir bir işlem. Articles 14.3 and 151b means it must be executive, ICRE, affecting legal status, capable of implementation.
Needs to have real legal teeth.
But the source notes some precedents where even some non-definitive actions were allowed to be litigated, depending on circumstances, so some flexibility exists.
While the general rule requires finality and enforceability, courts might consider practical impact and potential harm even from actions not strictly meeting that definition.
Another ground for rejection, exceeding the time limit, Surashima, filed too late, dismissed without looking at merits.
Calculation involves careful counting, checking holidays, considering suspensions like admin reconsideration. Court also checks if you were properly informed about the deadline, Constitution Art 40.
If Surashima is established, lawsuit rejected, and determining the start date of the period is the crucial first step.
Strict adherence to time limits is vital. Court's careful check ensures fairness and certainty, preventing stale claims.
Final review questions on first examination, which is not examined. Type of lawsuit, davaturu, jurisdiction, garev, venue, yeki, time limit, pseudosur, proper defendant, husumet.
Type of lawsuit, davaturu. Initial focus is on more fundamental procedural jurisdictional prerequisites.
Correct statement about the procedure. If petition is incomplete, plaintiff is granted time to rectify.
Highlights the chance to fix minor errors, promotes access to justice.
Types of decisions after first examination. Rejection, lack of jurisdiction, venue, standing, time bar, etc. Referral to competent admin authority. Granting time to correct for formal deficiencies.
Variety of outcomes reflecting the goal of ensuring cases are properly before the court or directing them elsewhere or allowing fixes.
Brief outline of the procedure. Designated judge reviews petition for compliance. Jurisdiction, venue, standing, subject matter, time limit, defendant, petition format. Arts 3 and 5.
Crucial initial screening for fundamental flaws. Safeguards efficiency and integrity.
Meaning and consequences of petition rejection. Indicates a fundamental flaw. Often, a 30-day window to refile corrected, if fixable. Failure to fix or repeating errors leads to dismissal. Some rejection decisions are appealable.
Rejection isn't always the end, especially for procedural errors, but underscores the need to get it right from the start.
Let's move to a really important tool. Stay of execution, Yürütmenin durdurulması. Article 27. General rule. Filing a lawsuit does not automatically stop the challenged administrative action.
Key point. Unlike some systems, you have to actively request a stay. It's not automatic upon filing.
The law sets two conditions that must both be met simultaneously for a stay to be granted. First, risk of irreparable harm or harm extremely difficult to compensate later if the action proceeds.
Think demolition. Once it's down, it's down. Irreversible harm.
Second, the administrative action must be clearly illegal. Not just arguably illegal, but readily apparent illegality.
High threshold. Harm must be substantial, reversible, and the legal flaw obvious at this early stage.
These decisions need written justification, usually made after the defendant admin submits its defense or their deadline passes.
Requires careful analysis by the court.
Exception. For actions that would become moot upon implementation, though not personnel actions like appointments transfers.
Right.
A stay can be granted without waiting for the defense, but it will be reconsidered after the defense comes in.
Temporary measure for urgent, irreversible situations, pending full arguments. Personnel actions generally don't qualify for this immediate stay.
When a stay is granted, the decision must explain the reasons for clear illegality.
Right.
And it describe the irreparable harm. Justification is mandatory.
Underscores the seriousness of halting an executive decision. Ensures reasoned analysis.
A stay cannot be granted just because the underlying law has been challenged at the Constitutional Court. The admin court needs his own finding of clear illegality in the specific action.
Right, separate issues.
Also, if the petition and documents clearly show the stay request is unfounded, the court can reject it immediately without waiting for the defense.
Quick disposal of meritless requests saves time.
Special rule for tax courts. Filing a suit disputing a tax assessment automatically stays collection of the contested amount. Taxes, fees, interest, penalties.
Automatic stay in tax cases. Big difference.
Yes, but this automatic stay doesn't apply if the tax file was removed from proceedings, or for suits challenging collection procedures themselves, or based on declarations with reservations. In those cases, you need to request a formal stay.
The automatic stay acknowledges potential financial hardship, providing protection while the dispute is heard.
Let's recap those two key conditions from Article 272 for a stay, outside the tax auto stay. Potential for irreparable or extremely hard to compensate harm if action proceeds, focuses on irreversible consequences, and clear, obvious illegality of the admin action itself.
Stringent conditions reflecting the impact of halting an executive action must be compelling grounds.
And Article 272 requires justification when granting a stay. No justification needed for rejection, but mandatory for granting. Source notes proving both irreparable harm and clear illegality is often a big hurdle in practice.
The justification requirement ensures reasoned decisions, not arbitrary ones, but meeting both criteria can be challenging.
Article 276 mentions requiring security teminent for a stay, but the source says it's rarely applied.
Legal option, but courts seem to focus more on harm and illegality.
And just to reiterate the tax rule, Article 274, automatic stay of collection upon filing suit. Rationale. Less harm in delaying collection. If tax is annulled, no loss. If upheld, can be collected later with interest.
Policy decision favoring taxpayer protection during disputes over immediate collection.
Our source summarizes two council of state decisions on stay requests. First, a regulation about judicial police reporting prosecutor orders to police superiors. Council found it interfered with judicial independence, encroached on judicial authority, violated separation of powers, risked investigation confidentiality.
Serious legal flaws identified.
Consequently, found clearly illegal regarding authority, granted stay citing potential irreparable harm to judicial functioning. Shows what clear illegality and irreparable harm can look like.
Strong example where the flaw hit core principles in other branches, justifying the stay.
Second case. 2010 SBS exam challenged a single-answer key for foreign languages. Plaintiff argued unfair disadvantage for those studying in a second language. Lack of warning.
Okay.
Council of State rejected the stay request. Reasoned the exam aimed for equality. Using one key prevented privilege for some students, upheld equality principle. Found no clear illegality or irreparable harm.
Shows even if unfairness is argued, if no clear legal breach or irreversible harm is found by the court's assessment, stay won't be granted. Requires weighing against broader principles.
Review questions on stay of execution. Filing a lawsuit automatically stays execution.
No. Requires a specific request.
What is not a condition for granting a stay? Court deciding ex officio on its own initiative.
Right. Actual conditions. Request. Clear illegality, irreparable harm, considering admin defense or deadline expiry. Needs party request.
Period for objecting to a stay decision.
7 days. Short time frame. Needs quick action.
Incorrect statement. Stay decision can be given without justification.
False. Justification IS required for granting a stay.
Incorrect statement. Court can issue stay without a request.
False. Request IS required underscores need for party initiative and court justification.
Let's move to expert witnesses Bilerki-Schielik. Article 31 says this is regulated by reference to the Civil Procedure Law, HMK.
Okay, so admin courts borrow the rules from civil courts here.
Exactly. Selection is based on lists from expert witness regional boards, but all other procedures, duties, rules, obligations follow the expert witness law and the detailed HMK provisions. Law number 6100.
Reliance on HMK provides a comprehensive framework for managing experts' appointment, scope, oaths, disqualification, reporting objections, evaluation, liability, fees, etc. Admin law adopts this whole structure.
The source summarizes a Council of State decision, emphasizing the need for courts to justify rejecting an expert report. Case involved whether constructions needed a permit under zoning law. Court got an expert report but didn't rely on it.
What did the council say?
Ruled that if a court requests an expert report due to specialized issues, it must address the report in its decision. If it disregards the expert's findings, it must clearly explain why. Ensures transparency and reasoned decision-making when expert evidence is involved.
Underscores giving proper weight to expert opinions in technical cases and the obligation for reasoned deviation if the court disagrees.
The source adds a philosophical note. Legal professionals should strive for what's right, act ethically. Ignoring expert advice without sound reason undermines integrity.
Ethical responsibility to base decisions on thorough, objective assessment of all evidence, including expert views.
Finally, H&K Article 267 on number of experts.
Oh.
Court usually appoints one, but can appoint an odd-numbered panel if clearly justified. Source suggests this might reflect awareness of expert witnessing becoming a profession, maybe involving file sharing.
Provides flexibility for courts to get needed expertise, potentially multiple perspectives if justified, especially in complex technical areas.
Let's talk hearings durusma. Articles 17 and 19 of IYUK.
Opportunity for oral arguments.
Key points. In annulment lawsuits, a hearing must be held if a party requests it. Judge has no discretion at trial level here.
Okay, mandatory if requested in annulment cases.
Same for full remedy and tax lawsuits, but even if the amount in dispute exceeds 44,000 Turkish lira. Below that threshold, a hearing is discretionary, even if requested.
Balances right to be heard with efficiency for smaller claims.
Article 171 makes it mandatory in those specified cases upon request. But Article 172 says hearings and appeals, Temias v. Steen of Florida, depend on party request and the appellate court's decision. So discretion exists at the appeal stage.
Difference between trial and appeal regarding hearing discretion.
When can you request a hearing? Article 173 says, in the lawsuit petition, or in the response's defenses, not after the initial exchange of pleadings is complete.
Gotta ask early on.
Both plaintiff, in petition or reply, and defendant, only in defense petition, can request limited window.
Ensures court knows early, helps planning.
Article 19 says after a hearing, a decision should be given within 15 days max. And if an interim decision, arakari, was made, the file gets priority review after it's implemented. Aims for prompt resolution after hearings.
Time frame encourages timely decisions post-hearing. Prioritization after interim orders keeps things moving.
Before we get into Turkish decision-making, the force mentions France again. French courts can issue injunctions to compel admin bodies to implement decisions, even appointing someone to ensure it if they resist.
Potentially stronger enforcement mechanism than discussed for Turkey. Highlights different approaches to ensuring compliance.
In Turkey, the decision-making process and required elements of decisions are in Articles 22, 23, 24 of IYUK.
Provides the framework for deliberation and formal judgment issuance. Structure, uniformity, transparency.
Article 22, reaching a decision. After issues clarified, vote in order. Minority judges on procedure jurisdiction still vote on merits. Dissenting opinions recorded.
Collective decision, but minority views documented, preserves different perspectives.
Article 23, minutes to Tanaklar. Detailed minutes kept for each file. Names of judges, prosecutor, counsel of state, examining judge, parties, case number, summary, outcome, majority-minority views. Signed by participating judges, kept in file.
Formal, permanent record of deliberations. Promotes accountability and transparency.
Article 24, elements of decisions. Decisions must include parties' names, titles, addresses, and reps. Summary of plaintiff's claims grounds request. Summary of defendant's defense. Examining judge prosecutor names opinions, counsel of state. If hearing held, who attended. Reasoning and legal provisions relied upon. The decision reached. Date written, names of participating judges.
Very structured. Ensures decisions are clear, well-reasoned, transparent, fully documented. Essential for parties and future review.
Now explaining and correcting errors in decisions, Articles 29 and 30.
Mechanisms to address ambiguities or mistakes after judgment, potentially avoiding full appeals.
Article 29, explanations of Shiklam. If a decision seems unclear or contradictory, parties can petition for explanation or rectification of contradiction. Petition submitted. Copies needed. Court reviews, maybe asks other side to respond. Court issues clarifying decision, can be requested any time until decision enforced.
Allows parties to seek formal clarification of ambiguities or internal inconsistencies. Promotes understanding and smoother enforcement.
Article 30, correction of errors, jämlichkeit duzeltilmäßig. Allows correcting specific errors. Mistakes in party names titles, stated outcome, arithmetic errors in judgment clause. Different from explanation, addresses actual mistakes in writing.
Right, like typos, calculation errors, clear, obvious errors, not legal reasoning flaws. Sometimes even clear grammatical errors changing meaning if context is obvious. Ensures written record matches, intended decision, efficient correction of factual clerical calculation errors.
Review question on limitations of administrative court's powers. Correct answer. They only conduct judicial review for legality. Sadece hukuka, uguluk denetimi yapmak.
Right. They don't usually step into policy or discretion, instruct admin how to act, or replace admin decisions. Role is ensuring lawfulness, reflects separation of powers.
More review questions on proceedings. Insignificant deficiencies in a decision can be rectified later.
Yes, aligns with Article 30 on error correction. Ensures formal mistakes don't invalidate sound decisions.
Incorrect statement. Courts can hold hearings even without request.
False. At trial level, hearing usually requires party request in specified cases.
Correct statement. Hearing requests can only be made during exchange of petitions.
Right, need to ask early.
Incorrect statement. Expert witnesses cannot be consulted in admin jurisdiction.
False. Experts are used via HMK rules. The related point that experts aren't consulted on purely legal matters is generally true. That's the judge's job. Experts provide technical factual input.
Now, waiver, Farragut, proof, ispat, and evidence deliver in administrative jurisdiction. Specifics and differences from civil courts.
Essential concepts. Abandoning claims, proving facts, presenting information. Crucial for litigants.
Waiver, Farragut. IYUK itself doesn't cover it. Article 31 points to HMK, Civil Procedure Law, HMK 307. Waiver of probity is plaintiff partially fully abandoning claim.
Okay, governed by civil rules.
HMK 309. Waiver by petition or orally adhering. Doesn't need opponents or court's consent. Partial waiver must specify part abandoned. Must be unconditional.
Clear framework for voluntary relinquishment.
HMK 310. Waiver possible any time until judgment final. HMK 311. Waiver has legal effect of final judgment. Only revocable for defect of consent, coercion, fraud.
Binding and generally irreversible.
HMK 312. Waiving party pays costs for waived part as if lost, unless defendant didn't cause suit and accepted claim at first hearing.
Rules on timing, consequences, costs.
Source highlights a crucial difference in context. Civil cases, usually waiving private rights. Admin cases often involve public interest. Action by one plaintiff, for example, environmental group, affects many. Waiver leads to decision on not rendering a judgment. KVYO Kurai.
That public interest dimension is key. Tension between party autonomy and broader public good. Private waiver might not protect wider interests.
Source raises potential problems. Associations filing suits maybe for financial gain, then waiving after private settlement. This could prevent judicial review of illegal actions, especially if others miss deadlines assuming the case would proceed. Ethical concerns.
Highlights conflict between private settlement and public accountability. Strategic waivers for private gain could undermine the system's integrity.
Source notes varying opinions within the Council of State on waivers in public interest cases. Some chambers more resistant than others. Ongoing debate.
Lack of complete consensus suggests this area is still evolving. How far does the right to waive extend in public interest matters?
Leads to a big question. Should the law specifically regulate limit waivers in public interest admin cases? Source even suggests maybe a provision saying waiver is not valid in such cases. Strong stance, prioritizing public interest over individual plaintiff's right to abandon suit.
Proposal highlights the concern that private deals shouldn't block enforcement of laws protecting the community. A difficult balance.
Now, proof and evidence. It's Batve delivered. Article 20, IYUK. Courts conduct necessary investigations ex officio, candela stindent. Proactive duty to seek facts, not just rely on parties. Can request documents info from parties and others, set deadlines, extendable once.
Defining characteristic, ex officio investigation, distinguishes it from party-driven civil process. Courts actively seek truth.
But limitations exist. State secrets. Turkey lacks a unified state secrets law. Craft exists. Current framework allows president, VP ministries to withhold info deemed state secrets.
Creates tension with fair trial principles, right to know evidence against you. How is this balanced?
Provision added in 1994. A decision cannot be based on a defense argued by relying on information and documents that were not provided to the other party. Crucial safeguard. State can withhold secrets, but can't use that undisclosed info as the sole basis for winning. Balances confidentiality and due process.
Essential rule. Prevents unfairness from secret evidence, protects secrets, but limits their use in judgments against a party who hasn't seen them.
So summary. Waiver follows civil rules but complicated by public interest issues. Proof evidence marked by ex officio investigation, balanced by state secret protection rules ensuring fair trial.
Highlights the unique aspects of admin procedure, balancing party rights, public interest, state needs, and fairness.
More review questions on this. Conditions for a waiver. Governed by H&K, plaintiff's voluntary act, partial complete, petition oral, no consent needed, unconditional, until judgment final.
Standard civil waiver conditions apply.
Waiver procedure. Plaintiff informs court, written oral. Court issues KVYO decision on not rendering judgment.
Formal recognition concludes proceedings on waived part.
Consequences of waiver, legal effect of final judgment, generally irrevocable, prevents appeals on waived part. Waiving party pays costs.
Serious final consequences legally and financially.
Burden of proof characteristics. Influenced by ex officio investigation. Often admin body needs to prove legality. But plaintiff still has initial burden. General principle. Who asserts must prove applies alongside court's active role.
Shared responsibility, but court's proactive role is distinctive. Allocation depends on specifics.
Means of proof. All legal evidence. Documents, correspondence, recordings, witness statements via HMK where applicable, expert reports, ex officio or requested.
Broad range available, plus court's own investigation powers. Allows thorough examination.
More waiver questions. Incorrect. Multiple plaintiffs must waive together. Each decides independently. Correct. Waiver is partial complete abandonment, result of party disposition, reflects freedom to seek abandoned rights, no reason needed.
Clarifies individual nature and underlying principles.
Correct statement on waiver procedure. Possible until judgment final.
Reinforces flexible timing.
Who cannot waive claim. Intervener. Mudahil. Capacity rests with principal parties, guardians, authorized reps attorneys.
Intervener support. Don't control the main claim.
Incorrect consequence of waiver. Can file new suit with opponent's consent. Waivers is final, generally prevents refiling. Correct consequences. Effect of final judgment. Irrevocable. Prevents appeal on waived part. Waiving party pays costs.
Underscores finality and binding nature.
Correct statements about proof. Claimant must prove claim. Subject of proof is material facts. Burden of proof can be determined by law.
Fundamental principles of evidence and proof allocation.
Now, legal remedies. Kanun Larda. Mechanisms for reviewing final decisions of first instance courts. Ordinary, istinav, temias, and extraordinary, kanun yararina demis, yargalanmanen yinelin mesi.
Crucial for correcting errors, ensuring accuracy, consistency, fairness via higher court review.
Source touches on whether all decisions should be appealable. Mentions a case challenging a law making certain board judge decisions final. Constitutional Court noted Constitution doesn't explicitly require all decisions be appealable. Precedents allow limiting appeal routes if public interest rule of law requires.
Delicate balance. Right to review versus need for efficiency, finality in some areas. Constitution allows legislative limits on appeal routes if justified.
Ordinary remedy. Appeal to Regional Administrative Court, SIDNAV. Introduced by Law Number 2576. Regional courts have appeal chambers. Review decisions of admin courts in their region. Council of State is appellate instance for some regional court decisions, often a two-tier ordinary appeal system.
Intermediate appeal level. Reduces Council of State workload, provides accessible initial review of lower court decisions.
Istinaf process. Provisional Art 6. Appeal lodged with first instance court within 30 days of notification. Regional court reviews procedure A&D merits. Can dismiss appeal if clearly unfounded. If disagrees with lower court, accepts appeal, annuls decision, issues new decision on merits, can request info via istinabe judicial assistance, can rectify factual errors if non-essential. Decisions generally final except for specific cases allowed further appeal, temyiz, to Council of State.
Thorough review, procedure merits. Regional court often has final say, promoting efficiency at regional level.
Ordinary remedy. Final appeal to Council of State, temyiz, provisional art. 6. For admin tax court decisions not subject to istinaf, A&D for regional court decisions where istinaf was permitted and pursued. Highest ordinary review for certain cases.
Final step in ordinary appeal process for cases bypassing istinaf or allowed further review after regional court.
Grounds for temyiz: violation of law, significant factual errors influencing judgment, failure to comply with procedural rules warranting annulment must point to specific legal procedural error.
Focuses counsel review on correcting significant errors in law, fact-finding, or essential procedure, not just reevaluating merits.
temyiz procedure. Petition to lower court within 30 days. Counsel first checks formal requirements, fees, content, timeliness, appealability, fails formality check, dismissed finally, passes check. Counsel reviews on temyiz grounds, finds decision unlawful, annuls, sends back to lower court for new ruling, lower court must comply, finds no grounds, rejects temyiz, lower decision becomes final.
Multi-stage process. Formal checks first. Substantive review only if formally sound. Clear outcomes. Annulment, remand, or rejection finality.
Crucially, seeking istinaf or temyiz does not automatically stay execution of lower court decision. Needs separate requests for stay. Kanun yolunda yürütmenin durdurulması art. 52.
Right. Appeal and stay are separate requests.
Request stay from first instance court or appellate court, regional for istinaf, counsel for temyiz. Decision made by appellate court or sometimes first instance. Need same conditions as initial stay. Arga 27. Irreparable harm, clear legality. Decision on stay during appeal is final.
Parties must proactively request stay during appeal and meet the criteria. Decision on that stay isn't further appealable.
Key point. Requesting stay during temyiz doesn't require prior request rejection at first instance. New urgent circumstances might arise. Also, stay can be requested any time until case concludes, including during temyiz.
Flexibility acknowledged.
Source mentions French system, sursis à exécution, référé, allowing even pre-suit measures. Suggests Turkey might be evolving towards similar flexibility for urgent interim relief.
Growing recognition of need for effective ways to prevent harm during appeals. Potential future developments.
Extraordinary remedy. Appeal on points of law for public benefit. Kanun Yararina temyiz art 51. Initiated by Chief Public Prosecutor of Council of State.
Okay, not by the parties.
If prosecutor deems a final admin tax court decision contrary to law, can request counsel annulment, even if parties didn't appeal or couldn't appeal. If counsel agrees, annuls decision BUT acquired rights of original parties not affected. Purpose: ensure uniform application of law. Annulled decision and counsel judgment published, sent to bar.
Unique mechanism. Maintains legal uniformity, corrects errors even without party appeal, prioritizes public interest in correct law application over individual finality in exceptional cases.
Extraordinary remedy. Retrial, Yargılan Manyan Yenila Mezi art 53. Challenges final, binding judgments on very specific serious grounds.
Reserved for fundamental flaws or new crucial info.
Grounds, Article 531. Forged influential documents found later. False influential testimony expert opinion found later by court. Decision based on bribery. Expert intentionally made false statement proven by court. Prevailing party used fraud affecting decision. Case decided without proper legal rep. Judge obligated to abstain participated. Subsequent conflicting judgment. Same party subject cause, no new basis. ECHR finds judgment violated convention.
Very high bar. Serious issues undermining original judgment.
Retrial request goes to court that issued original decision. Art 532. Time limits vary. Art 533. 10 years for conflicting judgments. 1 year from final ECHR decision. 60 days for other grounds from date ground realized by requester.
Varying deadlines reflect different grounds. Balances finality with need to address serious errors or rights violations even after judgment binding.
Final review on remedies, which is not an ordinary extraordinary remedy. Objection itiraz, temyiz, istinaf, yargılamanin yenilenmesi, kanun yararına temyiz.
Itira's objection in this context, others are the formal remedies.
Appellate authority in istinaf.
Regional Administrative Court, Bolje Dare Makamezi, primary appeal level for most cases.
Grounds for temyiz to Council of State.
Violation of law, significant factual errors affecting judgment, failure to comply with essential procedural rules. Focus on correcting substantial errors.
Duties of Regional Administrative Court.
Appellate review of admin tax court decisions in their region. First level of ordinary appeal.
Briefly explain kanun yararına temyiz.
Appeal by Chief Public Prosecutor of Council of State. Annuls final decision contrary to law, even if unappealed by parties. Doesn't affect acquired rights. Ensures uniform law application. Serves public interest and legal correctness.
Nearly there. One final area, public oversight and alternative dispute resolution. Source mentions Ombudsman Institution, Kamu Denetili Kurumu.
An alternative to courts.
Yeah, a mechanism for oversight and resolving disputes outside the formal system. Even if admin doesn't comply with Ombudsman's recommendation, a favorable opinion strengthens a later lawsuit. Shows another state body recognize the grievance. Can lead to easier court ruling. Ombudsman process is quasi-judicial. Claims, responses, reports, negotiations, decisions. Worth checking their website for examples.
Valuable avenue outside complex court system. Independent assessments can promote accountability, potentially avoid litigation.
Source has a fascinating historical anecdote. Ombudsman concept might have Ottoman roots. King Charles XII of Sweden, Demir Basho, took refuge there after losing to Russia. Couldn't go home. Appointed a representative to rule in absentia, seen as precursor to ombudsman. Spread from there.
Wow, surprising origin story. Adds rich context. Highlights enduring need for independent oversight of government power.
Similar institutions evolved elsewhere, like French mediateur becoming défenseur des droits. In Turkey, there's a trend of creating internal admin review mechanisms too, trying to resolve disputes before court. Reflects concerns about length complexity of judicial process. Ombudsman is most established of these alternatives.
Trend towards internal resolution and independent oversight bodies like Ombudsman. Aims to improve efficiency, accessibility, responsiveness, maybe reduce court burden.
Source concludes with a reflection. Printables versus detailed rules. In many countries, despite detailed rules, arbitrary enforcement happens. Underscores need for strong oversight like Ombudsman. Provides check balance, ensuring rules applied fairly, consistently.
Emphasizes rules aren't enough. Independent oversight is critical for ensuring just application and holding admin accountable.
So as we wrap up this deep dive into Turkish administrative jurisdiction, we covered court structure, Council of State, regional, admin, tax, jurisdictional dispute, lawsuit types, annulment, full remedy, procedures, deadlines, first examination, stay of execution, experts, hearings, decisions. Legal remedies, istinaf temyiz, kanun yararına temyiz, yargılanmanın yenilenmesi, and alternative oversight like the Ombudsman.
Provides a foundational understanding of the key structures, procedures, remedies. Highlights unique characteristics and vital role in accountability and dispute resolution.
Our aim, as always, was to give you, our listener, a clear, insightful overview of this intricate area, the key concepts, without drowning you in detail.
We really hope this deep dive shed light on the complexities and gave you a valuable shortcut to understanding this significant field.
And now, a final thought for you to ponder. Consider that fundamental tension between ensuring robust judicial review of administrative actions, holding government accountable, and creating efficient, accessible alternatives for resolving disputes outside the formal, often lengthy court system. How can societies best strike that delicate balance, protecting individual rights while enabling effective, efficient governance? We encourage you to explore the specific laws and decisions we mentioned for an even deeper understanding. Thank you for joining us on The Deep Dive.